everyone. My name is Odette, as introduced by Ian. I've joined MDA Consulting early 2012, and I've been in their employment for the past 5 years. At today's session, or the short session that we have, we're going to discuss the FIDIC White Book, which is the Client or Consultant Model Services Agreement, the 5th edition, 2017, which has recently been issued or published by FIDIC. It is mostly used by consulting engineers, whether they form part of the contractors-led design team or whether it's the employers-led design team. In a comparison with the 4th edition was only 12 pages, where the 5th edition is now 24 pages. It includes 2 new clauses and also include a number of amendments to previous provisions. It also includes 50 new definitions in total. It reflects up-to-date FIDIC terms and styles. It provides much more clarity, and there's also a balance between the risk between the client and the consultant. It also reflects current practices, specialist nature of this type of work, and provides a practical contractual basis for working. During July, MDA had like a FIDIC breakfast series during which we've actually discussed this FIDIC White Book, and we just highlighted the significant changes to the general conditions. Those significant changes were the intellectual property, the obligation to act in good faith, standard of care, construction administration, programming, exceptional event, variations, termination, and dispute resolution. I see some familiar faces today. I think some of you attended the breakfast series in July. So I'm going to discuss some of these aspects as well, but there are a few new provisions that we're going to discuss today. So the purpose of today's session is to have a brief discussion about the general provisions, the client, the consultant, time management under the FIDIC White Book, how variations actually work under the FIDIC White Book, the new clause introduced, it's the suspension and termination, liabilities, and then also dispute resolution. I will also provide you with some of my observations by just reading the contract, actually what I think about it. Everyone that's actually familiar with MDA will know we're actually a bunch of lawyers and one engineer, and we and we often sort of crack a few jokes with each other, so I thought it's good if I can maybe have one for today. So what is the definition of an engineer? It's someone who solves a problem you didn't know you had in a way you don't understand.
Can we have a definition of a lawyer, please?
It's coming. Okay, so the general conditions of the FIDIC White Book makes provision for definition of certain dates. It's dealt with in clauses 1.1.11 and 1.1.5. It provides for 2 dates, which is the effective date and the commencement date. Your effective date is the date on which the agreement comes into force and effect pursuant to clause 4.1. And then your commencement date is the commencement of the services, and it's the date identified in the particular conditions, or where no such date is identified, that the commencement date will be 14 days after your effective date. Then it also provides for a time for completion. This is not specifically a date, but more of a period within which you need to actually carry out the services. So it means the time for completing the services as stated in the particular conditions, or as may be amended in accordance with the agreement, and it's calculated from your commencement date. Then the general provisions or general conditions also provide for a definition of notices. In terms of the FIDIC White Book, you get 2 different types of notices in general, and then it also provides for a variation notice. What I've picked up throughout the contract, in certain aspects and in certain provisions, it gives you a certain time period within which you actually need to submit a notice, but in other aspects, it just says you need to do it promptly or as soon as reasonably practicable, which I believe will give rise actually which will be problematic because the parties may differ as to the interpretation, what means promptly and what means as soon as reasonably practicable. So the FIDIC White Book is also expressly states actually how a notice needs to be submitted and what needs to be contained in a notice. It's dealt with in clauses 1.1.19, 1.1.26, and 1.3. So it says it's a written communication identified as a notice or a variation notice in that actual document. So you need to say it is a notice in terms of. It needs to be issued in accordance with clause 1.3, which states that you need to refer to the clause under which the notice is issued. If it is not a notice and just another form of communication, it needs to be identified as such, and you also need to say the clause under which you're actually submitting it. It should also be in writing, and it needs to be delivered in the form agreed between the parties, whether you agree to electronic communication or delivery by hand. And if it needs to be delivered at an address, it needs to be delivered to the address in the particular conditions. Then the general conditions also includes changes in legislation. Clause 1.5 deals with it, and it says that the date for the change is no longer the effective date of the agreement, it is the date of the consultant's proposal or offer. And if the scope or the extent or the nature or type of services is affected by any change to the law or regulations, code or bylaw, which apply to the services, such change shall be treated as a variation under in terms of clause 5.1, which will actually give you an EOT and additional money. And then if any change in the country in which the services are required by the client causes the consultant to incur exceptional costs, we'll have a look at it, what it actually means. It will be adjusted in accordance with clause 7, and then your time for completion will be extended in terms of clause 4.4. We'll also have a look at that a little bit later. Then what is exceptional cost? Clause 1.1.12 define exceptional cost as cost arising out of necessary work, cost, expense, or delay incurred by the consultant, which is additional to the services, and a variation. An example of that is where the consultant is required to actually carry out its services for a prolonged period of a project, but where it was to no default of the consultant. So for that period that he needs to carry out his services, he'll be entitled to exceptional costs. It is also was necessary to perform and unavoidable, and where you're actually entitled to claim such exceptional costs, the contract will expressly say under which circumstances you can actually claim it. It's very similar to a FIDIC Red Book where it says you're entitled to cost with a capital C. In this instance, it will be exactly the same. Then the FIDIC White Book also provides for intellectual property under clause 1.7. It includes two definitions. It includes a definition for foreground intellectual property and background intellectual property. Background intellectual property, it is in respect of each party, the intellectual property that they created or that they had in their possession actually before the commencement of the services. And then the foreground intellectual property is created by the consultant while he's actually carrying out the services. In terms of the FIDIC White Book, each party will grant the other party a license to actually use and copy the intellectual property to carry out the services or for the purpose of the services. If you read clause 1.7, it also includes a right to the consultant to revoke any intellectual property license that he actually gave to the client if the client fails to pay him an amount that's due to him under the agreement. My observation of it, and I think maybe Siobhan can also maybe confirm, but that the task team was very careful when they said it's amounts due under the agreement, because I think sometimes there might be a difference in opinion between the parties or a dispute between the parties as to whether those amounts were actually due before you actually can exercise this right. Then the general conditions also provides for clause 1.10, which is an anti-corruption clause. This is not a new clause, but what is new about this clause is that this obligation is not only just placed on the consultant as per the fourth edition, but it's now placed on both parties. Should either party be in breach of this provision, either party can terminate with immediate effect. It also further states that the consultant needs to adhere to a code of conduct, and then it also provides for a minimum code of conduct, which is the FIDIC Code of Ethics and FIDIC Integrity Management System, which is accessible for all of us on a certain website. Then, when we look at the FIDIC White Book, and particularly the client and what the client's obligations is, clause 2.1.1 state that the client needs to provide all information which the consultant may require to carry out the services. He needs to provide it within a reasonable time, but with due regard to the program. So your program is dealt with under clause 4, but also in Appendix 4. And when you submit a program, you can have dates, or you can just put the dates in Appendix 4 as to when the client actually needs to provide you with all these required information. Then clause 2.1.2 takes it also a little bit further. It says that the client accepts responsibility for all the information provided by the client to the consultant. This allows the consultant to actually rely on the accuracy, the sufficiency, and consistency of information provided by the client. But when the consultant actually reviews the information provided by the client, he will still have to exercise a duty of care. Then clause 2.1.3 further states that should there be an error, ambiguity, or omission in the information provided by the client to the consultant needs to notify the client, and the client needs to rectify it by way of issuing a notice to the consultant, and it will also be dealt with as a variation under clause 5 of the contract. Should this actually give you rise to the services actually being delayed, you'll be entitled to an EOT and also possibly exceptional costs. Then, in terms of the FIDIC White Book, the consultant is dealt with under clause 3. Clause 3.3.1 particularly places a standard of care obligation on the consultant. It states that the consultant needs to exercise reasonable skill, care, and diligence to be expected from a consultant experienced in the provision of such services for projects of similar size, nature, and complexity. In certain instances in South Africa, you've got a common law duty of care, skill, and diligence. It's usually the form of fault against what is actually used to measure it is you need to be negligent, and it's usually measured against the standard of care of a reasonable person. But by reading actually the preamble of the FIDIC White Book and understanding the intention of the drafting committee actually is to create a balance of risk between the client and consultant, and to actually place a more experienced standard of care on the consultant by including the works expected from a consultant experienced in the provision of such services for projects of similar size, nature, and complexity. So it will not just be measured against a reasonable person, it will be measured against an experienced consultant. Then clause 3.3.2 states, the consultant shall perform the services with a view to satisfying any function and purpose that may be described on Appendix 1, which obviously sets out your scope of services. By reading a few articles that actually deals with and explain these clauses, a lot of people actually assume that this might be a fit-for-purpose obligation. But by reading the preamble, I don't think that was the intention of the drafting committee. It was purely to base a standard of care on the consultant. Then clause 3.9 includes, it's also a new clause, and it states that this FIDIC White Book can actually be used when a consultant is responsible for construction administration. The idea is that it can be more widely used together with another works contract, for example, your FIDIC Red Book, where you act as an engineer. That's where the consultant is providing construction administrative services under a works contract, and where he acts as an engineer, employer's representative, project manager, or similar. What is interesting, it includes a provision which states that the consultant shall act fairly as go between the client and the contractor, exercising independent professional judgment and using reasonable skill, care, and diligence. In my view, what it can mean is that where the consultant needs to act as an engineer under, say, for example, the FIDIC Red Book, where he either needs to make a determination under clause 3.5, or where he actually needs to assess a payment certificate, he needs to exercise independent professional judgment and using reasonable skill, care, and diligence when he actually carry out those duties under the FIDIC Red Book. The only difficulty is that the FIDIC Red Book doesn't actually include a similar provision, and the contractor is obviously not privy to the agreement between this consultant and the actual client. Then the further difficulty with this is that this clause also includes indemnity. So the consultant, whether he acts as a contract administrator, engineer, or project manager, in terms of subclauses 3.9.4 and 3.9.5, he's also indemnified by the client for the performance of the works contract by the contractor against any and all claims made by the contractor against the consultant arising out of or in connected with the works or the contract, and the means, techniques, methods, or sequencing of any aspect of the works contract. So I've got a problem with actually paragraph 2, where he's indemnified against any and all claims made by the contractor against the consultant arising out of or connected with the works and the contract, but where the previous clause actually said he's got a standard of duty and care that he actually needs to exercise. And it might be problematic, especially if he's responsible for the contract administration. Now he's indemnified against a claim by a contractor, but in terms of the previous clause, he actually owns the contractor a duty of care. Then the FIDIC White Book also deals with time management. This is dealt with under clause 4. By looking at it, the way this contract is actually put together, in my view, the consultant is also going to be more of a contractor. He'll have to submit programs, he'll have to submit updated progress programs, he'll have to submit notices and properly manage the time and the cost actually under this agreement. So clause 4.3 deals with your program. The consultant should submit his program within 14 days from the commencement date. If he submits his program and he receives no response or notice from the client within this 14 days, it's deemed accepted and he can proceed with the works or the services in accordance with it. And then your program is dealt with in Appendix 4. So when you compile actually your contract and you compile Appendix 4, it's very important to expand upon the requirements for the program to be included in Appendix 4, to insert any key dates when documents actually should be delivered, either by the client or the consultant to either party. It also needs to set out the requirements for the client for review and of the approval of the programs, and then also if there's a certain software that the client wants the consultant to submit its program in, it also needs to be stated in Appendix 4, and it also needs to deal with your monthly progress reporting requirements. Then under clause 4, and particularly clause 4.4, the contract also gives the entitlement now for consultant to claim an extension to the time for completion. Any of the following clauses may entitle the consultant to an extension. It includes a variation, any delay which is impediment or prevention caused by or attributable to the client or the client's other consultants, contractors, or other third parties. If there's an exceptional event, which we understand as a force majeure event, and any other event giving an entitlement under the agreement. My observation that I have, and where I think the difficulty is with this, is that it gives you the entitlement, but it doesn't take it further as to how will you determine your entitlement and how it will actually be implemented. It doesn't state whether you need to submit a notice, whether the client needs to agree as to the EOT that you're actually entitled to. So I think what would be interesting is if the task team or the drafting committee actually issued the guidelines in the beginning of next year, I think will hopefully address this issue. Then clause 4.5 also provides for the client with the option if he believes that it's in his reasonable opinion of the client, it's insufficient to ensure completion of the services within the time for completion. The client may give notice to that effect to the consultant. The consultant will then be obliged to submit a revised program and also methods, how he's actually going to catch up with his services. So this is very similar also to the FIDIC Red Book. Then if you have a look at this time management as a whole, there's no liability to pay compensation if the consultant actually fails to complete the services within the time for completion. So there's nothing like delay damages. My understanding or my view is that should it not be because of anyone else's default and you just fail to complete the services within the time for completion, you can be in breach of contract. And then, but should there obviously be a reason why you haven't complied or why you can't finish it within the time for completion, you will have to follow clause 4.4 to get an extension to the time for completion. Then a new clause in the FIDIC White Book is variations. What's important from reading this clause is that you need to agree the impact of the variation upfront with the client, and the client also needs to confirm the variation in writing. So clause 5.1.1 states that a variation can either be initiated by a variation notice, which is issued by the client, or the client may request for a proposal. The variation may not substantially change the extent or the nature of the services. Then the client has the right to amend the scope of services. He's also entitled to omit any services, but only where such services are no longer required by the client. He can't omit any services and then give it to someone else to carry out. He can change the sequence or timing of the services, and he can also change the method of implementation of the services. Clause 5.1.3 also further states that should there be an instruction or direction from the client which the consultant believes is a variation to the services, the consultant will have to issue a notice. He will have to detail the estimated impact upon the program and the cost of the services, and within 14 days from receiving such notice from the consultant, the client will either have to issue a variation notice, he will have to or cancel the instruction or direction, or issue a further notice saying that he's not in agreement with the consultant, and then the consultant will have the option to actually dispute it or not within 7 days. Clause 5.2 deals with the valuation and the impact of a variation, and it expressly states that the parties have to agree the value or method of calculation, including the impact of the variation. The way the variation will be valued is in accordance with the rates or the prices that's set out in Appendix 3. Should the rates or the prices that's listed in Appendix 3 not be applicable, new rates shall be agreed between the parties. Then the value and impact on the program should be agreed and confirmed in writing by the client within 14 days of receipt by the consultant of the variation notice. So the client's got 14 days from receiving this actual impact to say either whether he agree and confirm, and then the consultant may go ahead on receipt thereof. If there's no agreement reached between the parties within the 14 days, the client may by notice instruct the consultant to still commence with the work, but such instruction still needs to be in writing. And in the interim, while the parties may be trying to agree the actual valuation and the impact, the consultant will be compensated on a time spent basis at the rates or prices stated in Appendix 3. Should that not be applicable, it will obviously be reasonable rates and prices. Then suspension and termination was dealt with in the 4th edition, but Clause 6 is a new dedicated clause. It's more structured and it also provides more specific detail. It also separates the two and also give the differences between the effects of the two. So in terms of Clause 6.1.1, a client can suspend the works at his sole discretion for any reason. Should he decide to do it, he needs to give 28-day notice to the consultant. The consultant may suspend the works if the client fails to pay an invoice or a part thereof, and the client hasn't disputed that invoice within 7 days of receiving it. So previously, he had to give 28 days notice as to where here, if he hasn't given within 7 days notice and he hasn't paid you, you'll be able to suspend. You'll be able to suspend where an exceptional event arises. And this is an example. Should you elect to suspend the services, if there's an exceptional event like a force majeure event, you need to give a notice as soon as reasonably practicable, which can be interpreted in different ways. Should the client also fail to satisfy the client's financial arrangements under Clause 2.4, the consultant will also be entitled to suspend the works. What's the effects of suspension? This is dealt with under Clause 6.3. The consultant will be entitled to be paid for the services up to that date. If exceptional costs are incurred, the agreed remuneration will be adjusted in accordance with Clause 7.1.2. The time for completion will be amended in accordance with Clause 4.4, and then the consultant will have to issue a notice should he believes that he incurred exceptional costs as soon as reasonably practicable. There is an obligation on the consultant to take reasonable measures to mitigate the effects of suspension. Then Clause 6.4 deals with termination. The client's entitled to terminate if the consultant is in breach of the agreement. He can give a notice to the consultant to remedy the breach within 28 days. Should he not remedy the breach within 28 days, he needs to issue a further notice of 14 days. He is entitled to immediate termination should the consultant becomes bankrupt or insolvent or goes into liquidation, or, like I've previously stated, if the consultant is in breach of clause 1.10, which is your anti-corruption provisions. The client is also entitled to terminate for convenience, but is not entitled to carry out the work by himself or by someone else. Should he elect to do that, he needs to give the consultant 56 days notice. Then, should there also be a suspension of the services due to an exceptional event for more than 168 days, the client will also be entitled to terminate. Then the consultant is entitled to terminate if the suspension of services under clause 6.1.1 is longer for more than 168 days, which is the exceptional event, or if the suspension of services under clause 6.1.2a and c lasts longer for 42 days. That is in the event where he elects to suspend for convenience or for any reason, or where he actually fails to pay an invoice. Then also, this is actually just a repeat of bullet point 1. He will also be entitled to immediate termination should a client becomes bankrupt or insolvent or goes into liquidation, or as previously stated, where the client is in breach of clause 1.10, which is your anti-corruption provisions. What is the effect of termination? The effect of termination is that the consultant will be paid for services up to date. Should the agreement be terminated due to the consultant's default, the client will be entitled to all documents or deliverables pertaining to the services necessary to actually complete the services. He will also be entitled to reasonable costs incurred to complete the services. Should he not receive the documents or deliverables, he will also be entitled to actually withhold payment to the consultant. And the client's entitlement to cost is limited to that which were reasonably foreseeable at the time of the signature of the agreement. Then, should the client actually elect to terminate for convenience, the consultant will be entitled to exceptional costs. This will be the time extra spent by the consultant's personnel in the performance of the actual services. He will also be entitled to all other expenses reasonably incurred by the consultant. And then also, he will be entitled to claim loss of profit that would have otherwise been earned on the services not performed due to termination. This is in contrast with clause 8, which expressly states that neither party is liable for any indirect or consequential losses, which will include loss of profit. Then clause 8 deals with liabilities of both parties. The first provision is actually an obvious provision, but it's now expressly stated that either party is liable if either party is in breach of any provision of the agreement. Should either party be in breach of the agreement, the other party will be entitled to claim damages. Your damages will be limited to an amount of reasonably foreseeable loss and damage suffered as a direct result. It will also be limited to the amount stated in the particular conditions. And then you will only be entitled to damages suffered as a direct result of breach and not indirect or consequential losses. And that include like loss of profit, loss of business, etc. Then clause 8.2 actually provides for your time period within which you need to submit your claim for damages. So in South Africa and in terms of the Prescription Act, you usually have 3 years to submit a claim for damages. But should the parties agree to a shorter period in the particular conditions, they can actually do that. And then also what's interesting is to note that such period commences on completion of the services or termination of the agreement, and not necessarily actually when the event arose that actually gave you rise to the entitlement to actually claim damages. So which I think it's quite interesting from when you'll actually calculate that period. And then I'm not going to say too much about the dispute resolution provisions because certain aspects of it is very similar as to what Ewan discussed. But the dispute resolution provisions is in the FIDIC White Book, is dealt with in clause 10. They have deleted mediation and they've replaced it with adjudication. By just attending a webinar, the task committee actually said that the reason why they've actually deleted mediation is because the users actually told them it's not working. So they've replaced it with adjudication. Then it is also technically a 4-tier dispute resolution process. So it first provides for amicable dispute resolution between the senior representatives of the parties. Then secondly, it provides for adjudication. This is dealt with in clause 10.2 and also in appendix 5, which sets out the detailed adjudication procedures. What is also interesting to note is that the adjudicator has the jurisdiction to make a decision in his award which party is actually liable to pay his costs. So both parties will be liable for their own costs incurred during the adjudication if you had like legal representation, etc. But he can make an award on which party will actually be liable for his costs. And then should you not be happy with the adjudicator's decision, you'll have to issue a notice of dissatisfaction within 28 days, and then you also need to commence with the arbitration within 182 days. That's very similar as to what you discussed earlier. Should a party give a notice of dissatisfaction and they're on their way to the arbitration route, they'll have another opportunity to see if they can actually amicably settle the dispute. Should they not, it will be referred to arbitration within that 182 days. It's very similar to the conditions that you discussed. It's also international arbitration. The rules of arbitration is also the ICC, which I'm not sure if everyone's aware can be quite a costly exercise. So I think it might be one of the things that you definitely amend in your particular conditions. In the arbitration, the arbitrator will also have the jurisdiction to make a decision on costs that's got to do actually with the adjudication if either party actually failed or were like difficult in appointing the actual adjudicator. And then clause 10.5.1 also is a new provision which provides a party with the option, should a party fail to comply with the adjudicator's decision, if whether it's binding and whether it's final and binding, he can actually approach the arbitrator and ask the arbitrator to make actually an order to enforce the decision. So yeah, that's me for the day.